Bravo & Co Solicitors, committed to excellence.
My name is Elaine Addy and I'm based in the Mental Health Department. We would now like to talk about the case of MS and UK as a landmark ruling in relation to the fundamental dignity and human rights of mentally ill people. This ruling determined that the detention of a vulnerable, mentally ill man in police custody for over 3 days without necessary psychiatric treatment was an affront to his human dignity, contrary to Article 3 of the European Convention on Human Rights. On May 3, 2012, the European Court of Human Rights ruled that Mr S was denied the psychiatric treatment he urgently required. The court found that his detention beyond the legal limit of 72 hours in a place of safety excessively diminished his human dignity. His detention also amounted to degrading treatment contrary to Article 3 of the ECHR. It is important to stress that the police authorities never intended to humiliate or debase Mr S, and that this was irrelevant in determining their liability under Article 3. The facts of the case were that on Monday the 6th of December 2004, Mr S was arrested in the middle of the night. The police acknowledged that he was acutely mentally ill, so he was detained at the police station under Section 136 of the Mental Health Act 1983 as a place of safety. Mr S was assessed by a forensic medical doctor, 2 on-call psychiatrists and a community psychiatric nurse. They agreed that Mr S was suffering from a mental disorder of a nature and degree that warranted his attention in hospital for his own safety and health and for the protection of others for a period of assessment. It was decided that he would be immediately transferred to a hospital in Birmingham. Unfortunately, a number of delays occurred. On Tuesday the 7th of December, it was decided that there was inadequate evidence to charge Mr S with any offence. Mr S's mental state was observed to deteriorate. On Wednesday the 8th of December, Mr S was assessed by the Birmingham team. It was considered necessary for him to be taken to hospital. Unfortunately, a bed was not available for him. Mr S remained in the police cell beyond the legal limit of 72 hours. On Thursday the 9th of December, Mr S was released from police custody and escorted to the hospital in Birmingham. Unfortunately, by this time, his mental state had deteriorated so severely he required restraint by 8 members of staff. By way of compensation, Mr S was awarded €3,000 in non-pecuniary damages as his detention in the police station without access to psychiatric care amounted to degrading treatment. Even though there was no intention to humiliate or debase Mr S, it was found by the ECHR that the conditions which Mr S was required to endure were an affront to his human dignity. This is an important example of a case that reached the threshold of degrading treatment for the purposes of Article 3. Bravo & Co Solicitors will continue to support and advance the rights of vulnerable people through effective investigations and the legal system. For any advice surrounding mental health and public law, visit www.legalbravo.co.uk or call us on 0207 025 2020.